Jack Smith sat down before the House Judiciary Committee on January 22, 2026, and under oath, he said something the former president has spent years trying to bury. He told Congress there is proof beyond a reasonable doubt that Donald Trump engaged in a criminal scheme to prevent the lawful transfer of presidential power. Not speculation, not partisan opinion, proof. And he laid it out, point by point, over more than 5 hours of testimony. This was the first time the former special counsel defended his investigations publicly. He named the conduct, he named the evidence, he named the witnesses. And while Trump was live posting on Truth Social calling him a deranged animal, Smith calmly told lawmakers that he believes the current Department of Justice will try to indict him in retaliation. That's a sitting prosecutor telling Congress that the President of the United States has ordered his prosecution. That happened. On the record, the hearing itself was partisan and contentious. That was expected, but what cut through the noise was the substance. Smith testified that Trump willfully broke the law, the very laws he took an oath to uphold. He described a multi-pronged conspiracy, fabricating fraud claims Trump knew were false, manufacturing fake elector slates, pressuring state officials to ignore certified votes, pressuring the Department of Justice to halt certification, leaning on Vice President Mike Pence to intervene unlawfully, and then, when all of that failed, motivating an angry mob to march on the Capitol. Smith called the violence on January 6th foreseeable. That's not a throwaway line. That's a former war crimes prosecutor saying the sitting president understood what he was unleashing. Here's the part that complicates any defense. Smith testified that his most powerful evidence came from Republicans, not Democrats, not career bureaucrats with supposed axes to grind. Republicans, including former Vice President Mike Pence and GOP elector nominees who prioritized country above party allegiance. These are people inside Trump's orbit who cooperated with the investigation because they believed the conduct was that serious. And Trump's response? The same playbook. He called for Smith to be prosecuted. He labeled him an animal. He claimed the testimony was perjury, but none of that changes what's now in the congressional record. Smith's statements are under oath. Trump's posts on Truth Social are not. Now, let's be clear about what this testimony is and what it isn't. It does not resurrect the federal cases against Trump. Those were dismissed after his 2024 re-election, in accordance with a long-standing Justice Department policy against prosecuting sitting presidents. Jack Smith resigned after the election. The legal clock stopped, but what this testimony does is place the evidence, all of it, into the public domain, in a way the sealed court filings could not. That matters, because even though the cases are dead, the record is not. And if you're wondering why a Republican-led House committee would invite Smith to testify at all, the answer tells you something about the current state of political maneuvering. House Judiciary Chairman Jim Jordan, who has spent years calling these investigations politically motivated, wanted Smith on the stand to discredit him. He opened the hearing by declaring it was always about politics. But that strategy requires the witness to collapse under pressure. Smith didn't. He sat there, answered questions for over 5 hours, and returned again and again to the facts. He didn't raise his voice. He didn't engage with the theater. When Republican members accused him of running a partisan hit job, he replied that he had no partisan loyalties, that he would prosecute a Democrat or a Republican on the same facts, and that the evidence, not politics, drove every decision. That contrast was visible. On one side of the table, representatives shouting about weaponization. On the other, a prosecutor citing witness statements and legal standards. It doesn't mean Smith is right about everything, but it does mean the attacks on his credibility didn't land the way Jordan needed them to. Let's talk about what Smith actually said happened. According to his testimony, the scheme to overturn the 2020 election had multiple components. First, Trump and his allies spread false conspiracy theories about election rigging even after Trump was told by his own advisors that the claims were baseless. Second, they pressured state officials to disregard certified vote counts. Third, They attempted to create fraudulent slates of electors in states Trump lost. Fourth, they pressured the Department of Justice to intervene and halt certification. Fifth, they pressured Vice President Pence to refuse to certify the results during the January 6th joint session of Congress. And when none of that worked, Smith said, Trump motivated an angry mob to march on the Capitol. Smith was explicit. The violence was not incidental. It was foreseeable. And Trump exploited it even as it was unfolding. This is where Smith's background becomes relevant. He's not a career politician. Before leading the Trump investigations, he prosecuted war crimes at the International Criminal Court in The Hague. He spent years building cases against individuals who used violence and manipulation to seize or retain power. That experience informed how he described Trump's conduct. He called the fake elector scheme a form of affinity fraud, exploiting loyal supporters to execute an illegal plan. He characterized Trump as by a large measure the most culpable and most responsible person in the conspiracy. Republicans on the committee pushed back hard. They questioned the legitimacy of Smith's appointment. They accused him of timing his indictments to interfere with the 2024 election. They highlighted specific witnesses whose credibility they considered weak, including Cassidy Hutchinson, the former White House aide who testified that Trump lunged for the steering wheel of his limousine on January 6th. That claim was never corroborated by a Secret Service agent, and Smith's own team considered it too unreliable to use at trial. But Smith had a response for that too. He said he had so many witnesses that final decisions about who to call hadn't been made before the case was dismissed. He emphasized that his team interviewed state officials, campaign workers, lawyers, and advisors, many of them Republicans, who corroborated the core allegations. That's the part critics struggle to explain away. If the investigation was a partisan hit job, why were so many of the key witnesses members of Trump's own party? Why did Mike Pence cooperate? Why did state election officials, many of them Republicans, provide testimony supporting the special counsel's theory of the case? The Republican strategy in the hearing largely avoided engaging with that question. Instead, they focused on procedural criticisms. One of the most contentious involved subpoenas. Smith's team had issued subpoenas for phone toll records, metadata, not content, from at least 14 Republican lawmakers and over 400 Republican-affiliated individuals and entities as part of an FBI investigation known as Arctic Frost. Republicans argued this amounted to unconstitutional surveillance. They accused Smith of violating the speech or debate clause and hiding targets from judges. Smith defended the practice. He said the subpoenas were entirely lawful, approved by the Department of Justice's Public Integrity Section, and necessary to map the scope of the conspiracy. He pointed out that we did not choose those members. President Trump did, meaning the records were relevant because Trump had contacted those lawmakers as part of the alleged scheme. Texas Representative Chip Roy confronted Smith directly, asking, "Did you target my records?" The exchange was tense, but Smith's position was consistent. Toll records are a standard investigative tool, no content was accessed, and the relevance was determined by Trump's own communications. This is where the hearing revealed something important about how each side views the underlying events. For Republicans, the subpoenas were evidence of overreach, a prosecutor using the power of his office to surveil political opponents. For Democrats, the subpoenas were a logical step in tracing a criminal conspiracy that extended into Congress. Neither side persuaded the other, but that's not really the point. The point is that the facts Smith described are now part of the public record in a way they weren't before, and those facts don't go away because the cases were dismissed. Let's talk about what comes next. Smith made clear that he expects retaliation. He told lawmakers that "I believe they will do everything in their power to indict him because they've been ordered to by the president." He referenced Trump's social media posts during the hearing, in which Trump called for Smith's prosecution and accused him of perjury. This isn't hypothetical. The current administration has already fired over a dozen DOJ officials tied to Smith's investigations. Security clearances at law firms employing former members of Smith's team have been revoked. An executive order suspended clearances at Covington and Burling, where some of Smith's deputies now work. Smith described this as an attempt to chill associations with his investigation. There's also an open inquiry into Smith himself. The Office of Special Counsel, a different body from the Special Counsel office Smith led, is investigating whether he violated the Hatch Act, which restricts political activity by federal employees. That investigation was prompted by a complaint from Senator Tom Cotton. Smith's attorneys have called the inquiry imaginary and unfounded. But unfounded or not, the investigation exists, and it signals something broader about the moment we're in. A prosecutor who brought charges against the former president is now being investigated by the administration of the former president who is now the sitting president. That loop has closed. Smith addressed this directly. He warned that using prosecution as a political weapon threatens the rule of law. He said it sends a message that those crimes are okay, that it endangers election workers, and that it ultimately endangers democracy. He compared the current situation to the kinds of authoritarian regimes he prosecuted abroad. That's a heavy claim, and it's one Republicans reject entirely. From their perspective, the weaponization happened under Biden, when the Justice Department indicted a former president and political rival. They see Smith's investigations as the original sin, and any accountability measures now as a corrective. What's clear is that both sides believe the other is abusing power, and the institutions that are supposed to resolve those disputes, courts, Congress, the Justice Department, are themselves now objects of the dispute. Let's turn to the classified documents case, which Smith could not discuss in detail because of a court order. Judge Aileen Cannon, a Trump appointee, issued an injunction sealing Smith's final report on that investigation. The seal is meant to protect the trials of Trump's co-defendants, Walt Nauta and Carlos de Oliveira, who still face charges for obstruction and false statements. That seal is set to expire in February 2026 unless it's extended permanently, which Trump's lawyers have requested. If the report is unsealed, it would provide the public with Smith's full account of what he says happened at Mar-a-Lago, the willful retention of classified documents, the alleged obstruction of recovery efforts, and the threats to witnesses. Smith didn't accuse anyone by name during his testimony, but he did describe grave concerns about obstruction of justice, including threats to witnesses. He mentioned a social media post suggesting a witness be put to death. He referenced Trump's statement that if you come after me, I'm coming after you. Those aren't interpretations, they're quotes. And they raise questions about what happens to witnesses who cooperate with federal investigations when the subject of those investigations controls the federal government. The pardons are relevant here too. Trump issued mass pardons for January 6th defendants, including those who injured over 140 police officers. Smith called the pardons incomprehensible for violent offenders. Democrats argue the pardons send a signal that political violence on Trump's behalf will be rewarded. Republicans argue the prosecutions were excessive and politically motivated. What's not disputed is that the pardons happened, and they happened within days of Trump's return to office. That timing matters because it changes the calculus for anyone thinking about cooperating with future investigations. If the message is that loyalty will be rewarded and cooperation will be punished, fewer people cooperate. Smith seemed to understand this dynamic. He spent part of his testimony urging future prosecutors and investigators not to be deterred. He said, "I will not be intimidated," and he framed the work of the special counsel's office as essential to holding powerful figures accountable regardless of outcome. That's a long-term appeal, and it may or may not resonate with the people who have to make decisions about whether to take on politically sensitive cases in the future. But it's in the record now, and records have a way of mattering later, even when they're ignored in the moment. Now let's zoom out. What does this testimony mean in the broader context of American investigations into presidents? Special counsels and independent prosecutors have been a part of American political life since the 1870s. Ulysses Grant appointed a special prosecutor to investigate the whiskey ring scandal. That prosecutor was fired when the evidence got too close to Grant's inner circle. The Watergate investigation led to Richard Nixon's resignation after the Supreme Court ruled that executive privilege is not absolute. Ken Starr's investigation into Whitewater eventually expanded to include Bill Clinton's relationship with Monica Lewinsky, resulting in impeachment. Robert Mueller's investigation into Russian interference produced 34 indictments, but no charges against Trump because of a Justice Department policy holding that a sitting president cannot be indicted. Smith's investigations fit within that tradition, but they also depart from it in important ways. Unlike Mueller, Smith indicted a former president directly. Unlike Starr, Smith's cases didn't result in impeachment because Trump was re-elected before trial. Unlike Nixon, Trump didn't resign. He came back. That's the historical anomaly. A president was charged with crimes. The cases were dismissed because he won re-election, and he is now using the power of that office to pursue the people who investigated him. There's no direct precedent for that sequence. What the testimony also highlights is the fragility of accountability mechanisms. The special counsel regulations exist to provide independence, but those regulations can be challenged, as Judge Cannon did when she questioned Smith's appointment. The Department of Justice's independence can be compromised, as Smith argued is happening now. The courts can be shaped by appointments, as has happened at every level of the federal judiciary. And Congress, which is supposed to provide oversight, is divided along partisan lines that make consensus impossible. Smith said as much during the hearing. He told lawmakers that the rule of law is not self-executing. It depends on people choosing to enforce it, and he warned that if election interference goes unpunished, it can endanger election workers and ultimately our democracy. That warning is either prescient or partisan, depending on where you sit. But it's a warning that was delivered under oath to Congress by a prosecutor who spent his career pursuing corruption and war crimes. That doesn't make it true, but it does make it serious. The counter-arguments deserve attention. Republicans have argued that Smith's investigations were timed to interfere with the 2024 election. They point to the filing of a 165-page brief in September 2024, 32 days before the election, as evidence of political motivation. They argue that the subpoenas for Republican lawmakers' phone records were an unconstitutional overreach. They highlight the dismissal of the documents case by Judge Cannon as proof that Smith's appointment was legally flawed. Smith disputed all of those claims. He said his decisions followed Justice Department guidelines. He said the timing was dictated by legal requirements, not political calendars. He said the phone record subpoenas were standard practice and approved by internal review, and he noted that the Cannon ruling is being appealed and does not reflect settled law. What's clear is that neither side views the other as acting in good faith. Republicans see Smith as a Democratic operative using legal process to damage a political opponent. Democrats see Trump as a serial lawbreaker using political power to escape accountability. Those narratives are incompatible, and nothing in this testimony is going to change that. But what the testimony does change is the evidentiary record. Smith's statements are now documented. His reasoning is now public. The witnesses he relied on are now named. And the conduct he described, spreading false claims, pressuring officials, fabricating electors, inciting violence, is now part of the congressional record. That record can be cited. It can be referenced. It can be used in state prosecutions, civil lawsuits, bar complaints, and historical assessments. It doesn't have the force of a criminal conviction, but it has the weight of sworn testimony from a prosecutor who was there. The question that remains is whether any of that matters in a system where political power can override legal accountability. Trump is president. His Justice Department controls prosecutorial decisions. His appointees populate the federal bench. His allies run the committees that conduct oversight. And his critics are being investigated, fired, and publicly targeted. In that environment, testimony is limited in what it can accomplish. But it's not nothing. Records survive administrations. Facts persist beyond news cycles. And the people who put those facts into the record, under oath at personal risk, leave something behind that can be referenced when circumstances change. Jack Smith clearly believes circumstances will change. He told Congress that history will judge what happened. He said the conduct he investigated was without historical analog, and he expressed confidence that future generations will look at the evidence and draw conclusions. Whether that confidence is justified depends on things none of us can predict. But the evidence exists now. The testimony is complete, and the responsibility for what comes next passes from the prosecutor to everyone else. Smith ended his testimony with a warning. He said failing to hold powerful figures to the same legal standards as everyone else sends a message. It tells future office holders that crimes committed in pursuit of power will be tolerated. It tells election workers that their safety is negotiable. And it tells the public that the system bends for those with enough leverage to break it. That warning doesn't come with a solution. It doesn't come with a timeline for accountability. It doesn't come with guarantees. What it comes with is a record, documented, sworn, and now public, of what one prosecutor saw, what he charged, and why he believed it mattered. The system that's supposed to act on that record is the same system that's been captured by the person the record implicates, and that's where things stand. There are ongoing state cases in Georgia and Arizona. There are sealed reports that may be released. There are appeals pending and co-defendants awaiting trial. There are investigations into Smith himself that may or may not produce charges. And there's an administration openly committed to punishing everyone involved in the original investigations. None of those threads are resolved. All of them are moving. And the outcome of each will be shaped by decisions that haven't been made yet, by judges, prosecutors, jurors, voters, and the people who control access to the levers of justice. Jack Smith did what he could. He brought charges. He built cases. He testified under oath. And he left the rest to a system that may or may not be capable of doing anything with it. But let's be precise about what that system looks like right now, because the institutional landscape Smith's testimony enters is very different from the one he operated in when he was appointed in 2022. Start with the courts. The Supreme Court's ruling in Trump versus United States in 2024 expanded presidential immunity significantly. That ruling made it harder, not impossible, but harder, to prosecute a former president for official acts. Smith's team had to navigate that ruling when restructuring the election case, and the limitations it imposed contributed to the difficulty of bringing the matter to trial before Trump's re-election. The lower courts are also different. Judge Aileen Cannon, who dismissed the classified documents case and questioned the legality of Smith's appointment, remains on the bench. Her rulings may be appealed, but they've already shaped the trajectory of the investigation. And the broader pattern of judicial appointments over the past decade has produced a federal judiciary that is on average more skeptical of aggressive prosecution theories and more protective of executive power. Then there's Congress. The House Judiciary Committee that heard Smith's testimony is the same committee that has spent years investigating what it calls the weaponization of the federal government. Chairman Jim Jordan has been one of Trump's most vocal defenders. He was among the lawmakers whose phone records were subpoenaed by Smith's team. That's not a detail. That's a conflict of interest embedded in the oversight process itself. Democrats on the committee, led by Representative Jerry Nadler, tried to use the hearing to highlight the substance of Smith's findings. Nadler asked Smith directly about the evidence of Trump's criminal conduct and pushed for the release of sealed materials. But Democrats are in the minority. They can ask questions, but they can't set the agenda or issue subpoenas. Their role in this hearing was reactive, not directive. That division matters because congressional oversight is one of the few remaining mechanisms for accountability when the executive branch controls prosecutorial decisions. If Congress can't or won't act on the evidence Smith provided, the evidence sits in the record without consequence. It becomes historical, not operational. And then there's the Justice Department. The current Attorney General, Pam Bondi, has signaled alignment with Trump's priorities. The firing of officials connected to Smith's investigations began almost immediately after the inauguration. Smith testified that he believes those firings are retaliation, intended to punish people who participated in legitimate law enforcement work. The Office of Professional Responsibility, which reviews prosecutorial conduct, could theoretically investigate complaints against former members of Smith's team. The Office of Special Counsel, again a different body, is already investigating Smith himself. These investigations may or may not produce findings, but their existence creates a chilling effect. Career prosecutors considering whether to take on politically sensitive cases now have a recent example of what happens when those cases involve the person who later controls the department. Smith addressed this directly. He said that if prosecutors are punished for following the evidence, fewer prosecutors will follow the evidence. That's not a controversial observation. It's basic institutional logic. Incentives shape behavior, and the incentives for aggressive investigation of executive misconduct have shifted dramatically. Let's talk about the specific evidence Smith referenced in his testimony. He didn't just make broad claims, he named patterns and provided examples. On the fake elector scheme, Smith described a coordinated effort to create alternative slates of electors in states Trump lost. These electors were told they were serving as a contingency in case courts reversed the results. But the electors themselves weren't contingencies. They were submitted to Congress as if they were legitimate. Smith called this affinity fraud, exploiting people's loyalty to convince them to participate in something illegal. On the pressure campaign against state officials, Smith cited specific interactions between Trump and officials in Georgia, Arizona, and other swing states. The most famous of these is the recorded phone call in which Trump asked Georgia Secretary of State Brad Raffensperger to find 11,780 votes, exactly one more than he needed to win the state. That call wasn't leaked. It was recorded by Georgia officials who knew the request was improper. On the pressure against Vice President Pence, Smith described a sustained effort to convince Pence that he had the constitutional authority to reject electoral votes or delay certification. Legal experts inside and outside the administration told Trump this theory was wrong. Pence himself told Trump he didn't have that power. But Trump persisted, including in public remarks on January 6th that singled out Pence for criticism while the mob was breaching the Capitol. Smith called Pence's testimony among the most powerful evidence his team gathered. A sitting vice president testified against a sitting president, his running mate, his political ally, because he believed the conduct was that serious. That doesn't happen without reason. On January 6th itself, Smith said the violence was foreseeable and that Trump exploited it. This is a legal claim with specific implications. If Trump knew violence was likely and directed his supporters toward the Capitol anyway, that's different from reckless speech. Smith stopped short of saying Trump intended the violence, but he said Trump did not intervene to stop it and continued to pressure Pence even as the mob was inside the building. That's a pattern of conduct, not a single moment. Republicans challenged several of these claims. They argued that Trump genuinely believed the election was stolen, which would undermine the criminal intent required for some of the charges. Smith's response was that Trump was repeatedly informed by his own advisors that the fraud claims were false. At some point, continuing to make those claims isn't belief. It's willful disregard for the truth. That distinction matters legally. Fraud requires knowing falsehood. If Trump knew his claims were false and made them anyway to advance a scheme, that's fraud. If Trump genuinely believed the claims, even if they were objectively wrong, the criminal case becomes harder to prove. Smith testified that the evidence showed Trump knew. Republicans argued the evidence was ambiguous. The jury that never convened would have decided. Now, let's look at the witnesses. Smith said his team interviewed dozens of people who were present for the events in question. Many of them were Republicans. Many of them had supported Trump. And many of them provided testimony that corroborated the prosecution's theory. The critics focused on Cassidy Hutchinson. She was the White House aide who testified to the January 6th committee that Trump grabbed for the steering wheel of his motorcade when Secret Service agents refused to take him to the Capitol. That claim was dramatic. It was also never independently confirmed. A Secret Service agent in the vehicle disputed parts of her account. Smith acknowledged that his team had concerns about using Hutchinson's testimony at trial, but he also said the concerns were about specific details, not her overall credibility, and he emphasized that she was one of many witnesses, not the foundation of the case. That's an important distinction. Critics often focus on the weakest part of a prosecution to discredit the whole. But prosecutions don't rest on single witnesses. They rest on patterns, corroboration, and documentary evidence. Smith testified that his team had overwhelming evidence from multiple sources. Whether that evidence would have persuaded a jury is unknowable now. But the evidence exists. Let's address the Republican procedural objections more directly. The most sustained criticism involved the subpoenas for phone toll records. Smith's team, working with the FBI's Arctic Frost investigation, issued subpoenas to telecommunications companies for metadata on over 400 Republican-affiliated individuals and entities. The targets included lawmakers, party officials, and conservative organizations. Republicans called this spying. They argued that accessing lawmakers' records without their knowledge violated constitutional protections. They accused Smith of hiding the targets from judges to avoid scrutiny. Smith's response was technical, but important. Toll records are metadata. They show who called whom and when, not the content of the calls. Obtaining them through grand jury subpoenas is a standard investigative tool. The subpoenas were reviewed and approved by the Public Integrity Section of the Department of Justice, which handles politically sensitive investigations. And non-disclosure orders were used to prevent obstruction, a standard practice when targets might destroy evidence or coordinate stories. Whether this amounts to overreach depends on your view of the underlying investigation. If you believe the investigation was legitimate, the subpoenas were appropriate tools. If you believe the investigation was politically motivated, the subpoenas were instruments of abuse. The facts are the same. The framing is different. Smith also faced questions about his appointment. Judge Cannon ruled that Attorney General Garland lacked the authority to appoint a special counsel under existing statutes. That ruling is being appealed. Legal scholars are divided on its merits. But the ruling exists, and it gave ammunition to critics who argue the entire investigation was procedurally flawed from the start. Smith defended his appointment as consistent with long-standing practice. Special counsels have been appointed by attorneys general for decades, including Patrick Fitzgerald, Robert Mueller, and John Durham. The statutory basis for those appointments was similar to Smith's. If Cannon's reasoning prevails on appeal, it could affect not just Smith, but future special counsel investigations as well. That's a broader implication worth noting. The challenges to Smith's investigation aren't just about Trump. They're about the mechanisms for investigating executive misconduct. If those mechanisms can be dismantled through narrow procedural rulings, the ability to hold any president accountable diminishes. Now let's return to the political dynamics. Trump's response to the testimony was immediate and escalatory. While Smith was testifying, Trump posted on Truth Social that Smith was a deranged animal who committed large-scale perjury. He called for Smith to be barred from practicing law. He urged Attorney General Bondi to investigate Smith and what he called crooked witnesses. This is notable because Trump is the sitting president, and the Attorney General reports to him. When a president publicly calls for the prosecution of someone who investigated him, that's not commentary. That's a directive with institutional power behind it. Smith testified that he expects to be indicted. He said the administration will do everything in their power to pursue him because they've been ordered to by the president. He didn't say this with alarm or desperation. He said it calmly, as a factual prediction based on public statements. That calm was itself notable. Here is a former prosecutor, under oath, telling Congress that he expects the government to charge him with crimes as retaliation for doing his job, and he's saying it without asking for protection or seeking public sympathy. He's just putting it on the record. Whether that record provides any protection remains to be seen. The record didn't protect the DOJ officials who were fired. It didn't protect the law firms that lost security clearances. It hasn't prevented investigations from being opened, but it creates a documented baseline. If Smith is charged, there's a sworn record of what he said and why, entered before the charges were filed. That matters for appeals. It matters for public perception. It matters for history. Let's also note what Smith didn't say. He didn't accuse Trump of insurrection. He didn't call for impeachment. He didn't urge voters to oppose Trump or support any political party. He stayed within the lane of a prosecutor presenting evidence and defending investigative decisions. That restraint is meaningful. Prosecutors who become political advocates undermine their own credibility. Smith seemed aware of this. He answered questions about evidence. He pushed back on procedural criticisms, but he didn't editorialize about what voters should think or what Congress should do. He presented facts and left the conclusions to others. Democrats tried to draw him out. Representative Jamie Raskin praised Smith's fidelity to the rule of law and pushed for more public testimony on the classified documents case once the court seal lifts. Smith acknowledged the request, but didn't commit to future appearances. He's out of government now. He has no obligation to continue engaging. But the pressure for disclosure will continue. Media organizations and advocacy groups have filed legal challenges seeking to unseal Smith's final reports. If those challenges succeed, the public will have access to the full prosecutorial account of both investigations. That could revive public debate, influence state cases, and shape historical understanding. It could also provide material for Republican investigations into Smith's conduct. The state cases deserve specific attention. Georgia's RICO prosecution of Trump and 18 co-defendants remains active, though it has been slowed by procedural challenges. Arizona has indicted individuals involved in the fake elector scheme. New York's hush money conviction is on appeal. None of these cases depend directly on Smith's work, but they draw from the same evidentiary universe. Smith's testimony could indirectly support those cases. State prosecutors can reference federal findings. Witness testimony from the federal investigation could inform state witness preparation. And the public narrative established by Smith, that Trump knowingly engaged in a scheme to overturn the election, provides a framework for state jurors to evaluate similar evidence. Whether that matters depends on whether the state cases proceed. Georgia's case has been particularly troubled by controversies involving District Attorney Fani Willis. Arizona's case involves fewer defendants and may move faster. New York's appeal could take years. The landscape is fragmented and unpredictable. What's predictable is that the fight over the meaning of Smith's investigation will continue long after the testimony ends. Trump's supporters will continue to call it a politically motivated witch hunt. Trump's critics will continue to call it a legitimate effort to enforce the law. The evidence Smith gathered will be cited by both sides to support opposite conclusions. That's the nature of contested political ground. Facts don't resolve disputes when the interpretation of facts is itself the dispute, but facts exist independently of interpretations. Jack Smith spent more than 2 years gathering facts about what happened after the 2020 election. He testified about those facts under oath. He answered questions for over 5 hours. He faced hostile interrogation from lawmakers whose records he had subpoenaed. And he did not retract or soften any of the core claims. The record now contains his account. It contains the names of witnesses. It contains the description of conduct. It contains the legal theories his team developed. And it contains his warning about what happens when that conduct goes unpunished. The system will do with that record what the system does. But the record exists. It isn't going away. The next chapter depends on whether anyone else picks up where he left off, or whether the record he created becomes a monument to something that almost happened.